I welcome the eminent speaker, BC Thiruvengadam sir, fellow faculty members, and all my dear students. So, this is a talk on arbitration specifically today, and this session will surely give us a learning on the arbitration proceedings in India and its impact in the lines of the Arbitration and Conciliation Amendment Act of 2019. So, as sir has requested, I request everyone to switch off their videos and mute their audios throughout the session. Uh, our speaker will be addressing your questions and doubts after the session, by the end of the session, and you can put your questions only in the chat box. Now I would hand over to Vidya ma'am, who will be introducing our distinguished speaker, BC Thiruvengadam sir. Over to you, Vidya ma'am.
Thank you, Chandrarupa. Good afternoon, all. I take this opportunity to introduce our speaker today for this talk. Advocate Shri B.C. Thiruvengadam is a lawyer of over 4 decades of standing. He has a degree in commerce and law from Bangalore University and has an intermediate degree in chartered accountancy. He is a patent agent of the Government of India and a certified US patent process prosecutor from ASCI3 Center, Sunnyvale, California, and is a certified mediator by ISDL San Francisco and High Court of Karnataka. He is a Group A Counsel of the Government of India in the Supreme Court. He is the founder partner of Thiru and Thiru, a legal 500 law firm. Acclaimed as a specialist in the corporate oppression and mismanagement, he has expertise in the area of commercial law, intellectual property rights, energy law and constitution, and cross-border disputes. Thiru sir has attended several international arbitrations and an advocate as well as an arbitrator. He is an international mediator and has resolved several cross-border disputes in the area of corporate law, IPR, fashion law, and refugees. He has involved in establishing several court-annexed mediation centers in India, including Bangalore Mediation Center, the largest in India. He is the master trainer and trainer of trainers in mediation and arbitration and has trained thousands of mediators, including lawyers, including sitting High Court judges, Supreme Courts, company secretaries, and chartered accountants in India and abroad. He is the co-founder of Bangalore International Mediation Center, Intermediation, Arbitration and Conciliation Center, India's one and only non-for-profit comprehensive international institutional ADR center, which is among the top 25 international ADR center in the world. This center imparts training in various areas of dispute resolution and conflict management and is a resource center for several prestigious law schools in India. As a guest faculty, he teaches technology law at the Chicago-Kent College of Law, Illusion Institute of Technology, Chicago. He has rendered several lectures and technical papers in various universities and institutions in India and abroad. He represents the Society of India Law Firm, Bangalore, and is the Honorary President of the Corporate and Administrative Law Foundation. He is an active member of the International Council of Jurists, London, International Bar Association, London, Inter-Pacific Bar Association, Tokyo, INSOL International, New York, and Union of International Advocates, Paris. He is featured a prestigious LexisNexis 100 Legal Numerous of India. He is also featured as a leading lawyer by the Asian Law Journal's Legal 500, Chambers and Partners, Asia Business Law. On 27th April 2017, Davis A. Clark School of Law, University of District of Columbia, has honored him in recognition of his contribution to the worldwide legal community. Thank you, sir, for accepting our invitation and to be part of this talk today and to be a resource person. To add on, I would like to share that he is my senior under whom I started my career. I've learned quite a lot of the legal profession from him. He has been a leader, mentor, and guru to me and many more like me. I take this pride in taking the lessons learned under his guidance and pave way for my progress in my career. I take this opportunity to once again thank you, sir, and I hand over this session to you, sir. And we are very proud to have you here. Thank you.
Thank you very much for the very kind words, Professor Vidya. I'm also honored as I take note of the presence of Professor Dr. Subramaniam, whom I happened to meet in when he was heading the University Law College, where I went there to judge a couple of events. Thank you for the opportunity, sir. Well, coming back to the topic, as I said, I don't want to bore you children with just all about arbitration. I want you to learn more about arbitration, as to why arbitration, how it was formulated, and how did it develop over the period of time. I'll try to make it as interesting as possible. And please reserve your question. But let me start with a caveat. I'm not going to discuss any of the case laws, barring a couple of case laws. I want to kindle your inquisitiveness and your research capabilities to look for various case laws. We'll be flashing a list of cases at the end of this webinar, but it is up to you to learn more and more as to how the law regarding arbitration has evolved in this country. And law, as far as arbitration, has not been static. It is one of the most fluid law compared to any other law in this world. Everyone talk about ADR. Is it alternative dispute resolution or alternate dispute resolution? Friends, there's a distinction between alternative and alternate. I find people committing this mistake. Even some of the judges have used erroneously or interchanged these words often. I'm not saying the word using alternate is not right, but it's not often right, which again I'll explain to you during the course of this talk. So what is alternative? Alternative is having an option for a person to choose among various items. Whereas alternate is something to replace something. A substitute. You have a cricket match, and in the cricket match, there are cricket players. Okay. So what happens if one person gets hurt, a fielder, so you bring in a substitute. So there's an alternate. Or even before selecting, going for the cricket match itself, okay, I may drop one spinner, and alternate choice would be to bring in a pace bowler. So alternate is something to substitute something else. Alternate is something like a buffet spread in a restaurant where you pick and choose what you want. Okay, that is a fundamental difference between alternative and alternate. Okay. The next is it alternative or appropriate? Okay. Are we going to, among this alternate, are you going to choose a dispute resolution mechanism? And what is the criteria to choose a dispute resolution mechanism? On what basis are you going to do? Ultimately, it depends upon whether it's appropriate to do it or not. Now, assuming there is no contract between a party and there is no arbitration clause, and people decide to go to the court, people think that it's the only option available is litigation, right? So there is no alternative. One would think that, okay, go to litigation. Now, assuming there's a dispute between two commercial entities and there's an arbitration clause in a contract. Now, is there an alternative Or is there an alternate? Or is there an appropriate option for the parties to choose a forum? No. The only option available is that jurisdiction of the courts are ousted and you're compelled to participate in an arbitration proceedings. Okay. So set aside arbitration for a moment. Then you're left with choices. Okay. Assuming a person wants to litigate, before litigation, he or she may try to resolve the disputes by direct negotiation or the intervention of third parties or intervention of a neutral, or choose between various ADR options. So ultimately, in the modern world, the word ADR would refer to appropriate dispute resolution. You have no other choice. There's an arbitration clause. You have no other choice. That's the only appropriate one. If do not have a definitive arbitration clause in a contract, then you have various options. And to choose among these options, it's up to the parties to find out which is appropriate or not. Now, there are various foundations for various ADR options. And they are a combination of inquisitorial, adversarial, evaluative, and facilitative. Okay. So it can be inquisitorial, adversarial, evaluative. What is that? Inquisitorial, adversarial, evaluative, and facilitative. Evaluative and facilitative combination, and non-evaluative and facilitative. On the screen, you see various ADR options. Litigation. Is it inquisitorial? Yes. Adversarial? Yes. Evaluative? Yes. Facilitative? No. Is the process confidential? No. Is the process voluntary? No. Is it party-centric? No. Okay. This slide gives you a broad understanding of various ADR options and their characteristics. Next, we have arbitration. It is an inquisitorial process. It is adversarial. It is evaluative, but not a facilitative. Is it confidential? Yes, to an extent, partly confidential. But now the amendment says it has to be entirely confidential. Is it voluntary? It's not a voluntary option. Is it party-centric? No. Conciliation. Is it inquisitorial? Yes, it can be inquisitorial. It can be adversarial. It can be evaluative. It can also be facilitative. It is also confidential. It is voluntary. And it's also partly party-centric. When I say party-centric, it means that the parties are given importance and not the lawyers. The lawyers play a secondary role, supporting role to the parties, and parties are the ones who open and talk directly with the neutrals, whereas in a court or an arbitration proceedings, it is a lawyer who speaks and interacts on behalf of the client. Now we have the hybrid system of Lok Adalat, which is very peculiar and unique to India. So it is again inquisitorial, it can be adversarial, it can be evaluative, and it is also facilitative. But there is nothing confidential in the process, and it is supposed to be voluntary. At the same time, it's partly party-centric. Now coming to mediation, it is neither inquisitorial nor adversarial. It is also non-evaluative, but it is facilitative, confidential, voluntary process, and totally party-centric. Many of you may not even know of what neutral evaluation is, but neutral evaluation is one of the most blaming someone for something that has happened. Evaluative is again the process resulting from an inquisitorial option where you evaluate the merits of a case, demerits of a case, evaluate a person whether he or she is good or bad, etc. Whereas facilitative process, when it comes to mediation, in the absence of inquisitorial, adversarial, evaluative process, it's a challenge. A person has to be an effective communicator and ensure that the parties' minds are not prejudiced, being neutral totally altogether. Okay. Then the neutral evaluation process is also confidential. It is also voluntary and again party-centric. The concept of judicial settlement is provided under Section 89 CPC. However, it has not been effectively introduced. But those who are not aware of what judicial settlement is, this prevalent fairly widely abroad, where when a case is filed in a court, the case is assigned to a particular judge, and the judge does an evaluation, something like neutral evaluation. He goes through the entire case and finds out whose case is better, what are the chances of each party winning or losing, depending upon the prima facie evidence made available to him. Then the judge will call each of the parties separately and privately and confidentially and tell them, listen, I have gone through your case, I have gone through the evidences, documents that you have produced. You may have a good case, but I'm not sure that you may succeed, or you have an excellent case, you may succeed, but you may have a very bad case. So why don't you, depending upon the strength and weaknesses of the case, the judge may advise whether to go for a settlement or not, opt for any other neutral evaluation option, or ADR option like mediation or conciliation, etc. Then there is what is called collaborative settlement. That is also fairly popular, where the parties do not meet, but each one of them appoint a neutral who is also a trained mediator. It's two neutrals who are the one who meet each other, and they interact only between the parties. There's no cross interaction between a mediator or a neutral of one party with the opposite party. So again, it is not inquisitorial, it's not adversarial, but it can be evaluative, it can be facilitative, confidential, voluntary, and party-centric. And mentoring is what happens normally in workplaces and educational institutions, where a senior faculty member or a senior employee acts as a mentor in order to iron out problems between the students or between the staff or between the co-workers. So they resolve the dispute by mentoring. And again, it's not an inquisitive process, not an adversarial process, but it can be an evaluative process, facilitative, confidential, voluntary, etc. So friends, these are the broad ADR options that prevails and is being practiced fairly effectively around the world. Some of them have not been brought into India, but doesn't mean that it doesn't exist. It is being practiced in a small number. At BIMAC, we do practice a lot on all these options, except Lok Adalat, it's totally the domain of the courts. Now, the other distinction that needs to be drawn is conflict and dispute. What is conflict and what is dispute? Unfortunately, this being a webinar, I am deprived of the privilege to interact with you face to face. I love to interact with each one of you, go around you, discuss with all of you, and ask questions and answers. But unfortunately, I cannot do it here. So bear with me. So let us try to draw a distinction between conflict and dispute. I'll explain it in a very simple manner. Assuming there are two children, Ram and Sham, in a family, and one of the uncle comes and gives a gift, okay, say a toy train, okay. Now, they soon end up fighting over the gift, and the parents, as parents or the elder person in the house, one is disturbed because of noise and fight. So what are the options available to you or to your parents? The first option is take away and lock it away, and don't give it to any of the children. The next option is give it to the elder son. Okay, Ram, you're the elder son, you have it. Second option is give it to Sham, the younger one, saying that you're the kid, let the kid brother have. Or you can sit and play with the children together and see that they all are happy. The fourth option is to teach the children as to how to share and play, and you don't get involved. Now let us do an option analysis. Locking away the gift makes both the kids unhappy. Okay, so what are you trying to do? There is a conflict which persists because the kids are unhappy and both will be angry against each other because they will blame the other one for depriving the toy. The toy has been taken away by the parents. So the parents have tried to resolve a dispute, but not a conflict. Again, if the toy is given to either of the children, the other child remains unhappy and he'll have a grudge over the other person. So again, your moment thing you're trying to do is to remove stop the dispute, but the conflict simmers. And it's always not possible whenever they fight, you sit and play with them, right? So resolves the conflict. Neutral evaluation resolves the conflict. Collaborative settlement tries to resolve the conflict. Mentoring tries to resolve the conflict. All other ADR options exclude the conflict and only address the dispute. Kindly bear this in mind. So with this, you come to look at a stark reality. In a survey conducted in 2007, we found 52% of the population believe that courts or litigation not provide a solution. So straight away, 52% of them are of the population are totally excluded from the judicial and justice dispensation system by the courts and lawyers. 9% of the people believe that they can get justice by approaching the court. And 29% of people believe that to have an extra judicial method, like having a neutral person, like politician, police, bureaucrats, whether you call them neutral or not, to influence to get a dispute resolved. Less than 1% go for arbitration. I'm talking about arbitration today, and less than 1% of the disputants take arbitration as an option. But alarmingly, 9% of the disputants go to antisocial elements like underground and mafia to resolve the disputes. There are various reasons why people do not want to come to the court. That is the 52%. Some say custom and family, there is social stigma. People, like, for example, a person may be, a lady may be harassed into domestic violence, beaten by the husband, whatever it is, but yet she does not want a decree or divorce because it may be a stigma. About 26% feel that it is very expensive going to a lawyer, going to the courts, and about 14% feel that the outcome is uncertain. They're not very, very sure as to whether they'll win or not. And 37% feel that the outcome is uncertain. And 14% feel that the outcome is uncertain. And 37% consider that the inordinate delay and the results do not come out in time. So when we say only 9% of the disputants come to the court, 91% are excluded, but still we have a huge backlog of 35,000 cases in the Supreme Court and about 3 million cases in the High Court and subordinate courts. Plus there are several million cases pending in various tribunals. We don't have a statistics for that. And comparatively, there are 35 judges per million population in the US and 13 judges in India per million population. I was told it has come down to about 7 judges per million population. So our judges are doing a tremendous amount of work considering the number of cases they are handling. Approximately 200 cases are handled by a judge every day in India, whereas there are about 3 cases per day for the judge in the US handling it. Okay. Now, origin of dispute resolution, where might was the remedy. Okay, so it was violence that prevailed. And people became smart, and they decided that instead of they fighting, they can engage gladiators to fight their cause. Okay, today they call it Supari killings. Then in places like India and various other countries, they had something similar to panchayat systems, where 5 elderly men in a village or a community or a trade group decided to resolve disputes. Then the Britishers introduced the Adalat judicial systems. Now, coming to the history of arbitration, the first ever reference to something like arbitration was by Aristotle way back in ancient Greece. He discusses in detail as to how the system of arbitration the dispute can be resolved through arbitration. So there were what is called as private tribunals in ancient Rome, chaired by heads of families who were called as arbitrators, who were willing to listen to the parties and would resolve the dispute. Later on, as the trade and industrial development took place, every trade formed a guild. Guild is some sort of an associations. And every trade has a guild, and a dispute among the guild members were resolved by the guild itself. And every country has a guild, and there will be a counterpart guild in any other country. And if there is a tradesman from another country who visits, say from France, he visited England, and there was a dispute, he would go to the local guild to resolve the dispute as such. So the guild more or less functioned as arbitrators for disputes. Then in the 12th century, they were called the Court of Boroughs. They were chartered English, again, it's a takeoff from the English guilds and the borough governments, and they regulated the trade monopoly. And they were called as the Court of Boroughs, and regulate trade privileges, and the most important, they were settling disputes among the members and the community as such. Then, it is very common, even these days, we have what is called fair markets. Even in India, we are called Sante or Sante, whatever in each language. But on a particular day in a week, people used to come to a particular locality to sell their wares, and it was either barter system, whatever it is. It prevailed all over the world, and it was very, very prevalent even in the European community as such. Now, what happens is that when people come and try to sell, and if there is a dispute, they would not like to remain in the place for the dispute to be resolved. It may take some days and years. So it hampered their movement. So ultimately, it was decided that they should set up courts for all these wandering merchants. Okay. So what they created was, they created what is called courts of merchants or courts of the fair, and entire thing was dependent on fair law. There was no specific law as such. It all depended upon the common sense and practice which prevailed over that period of time. Then we had what is called the Pie Powder, or Court of Pie Powder in England. It was introduced by King Edward I, again on the same principle that no trader, no foreign merchant should be delayed or harassed because the dispute that he is involved with is getting delayed. So he created what is called the Pie Powder Courts, or dust from the courts, the literal meaning of it. And this is one of the places where the Pie Powder Courts which were held in the past. And ultimately, the statute of staple, or the Carta Martoria, came into place, and from which you have your mercantile law also being derived later. So the England introduced the statute of staple. These were additional courts created specially for merchants for speedy disposal of the case, and it was being done on an hourly basis. And the mayors and sheriffs of each particular area was asked to preside over these courts. And the jurisdiction of the regular civil courts were excluded from entertaining such claims because it's supposed to be very, very speedy. And later on, the Carta Martoria came in, and which appointed the merchants as juries to resolve the disputes. As the East India Company and trade across the seas took place, then there was disputes with respect to ships and shipping related other disputes. So the Admiralty Court came into place specifically to address speedily the disputes pertaining to shipping contracts involving foreign participants. Now, in the 17th and 18th century, the traders from various countries did not like the civil courts, and they found that the Court of Staple and Admiralty courts were taken over by lawyers and judges, and they were too technical as well as legal. And it defeated the entire purpose of having set up these courts because it became slow and time consuming. And the lawyers and judges were not able to understand the commercial problems. So they decided to come out with a charter to settle the disputes among themselves. The charter is a contract between two or more parties that in the event of a dispute and while performing or executing a contract, they shall resolve the disputes among themselves or by a person known to them. So this was the birth of the first modern arbitration. In the 19th century, the first codified law for arbitration was passed by England, and it was called the Common Law Procedure Act 1854, and it made mandatory reference for dispute for arbitration. As I said earlier, when the charter was created and people agreed to resolve the dispute through arbitration, some parties did not want to go through arbitration. They like to delay and frustrate the process and go to the civil court. So this was the first attempt by way of legislation to oust the jurisdiction of the civil court. And they say once you have agreed in a contract that you resolve the dispute through arbitration, you have to stick to this and do not go out of it. And whatever the arbitrator awards will be binding on you. Then in 1889, England came out with a new law. Then another law in 1975 that was replaced by 1979 law. And in the meanwhile, the United Nations came out with the UNCITRAL, where they came out with model law to resolve disputes among cross-border disputes, especially when there is a trading between one country and another, the trader of one country with trades with traders of other countries. There were bound to be disputes and how to be resolved. So a model law was recommended, and UNCITRAL Act of 1996, model law of 1976 was recommended, and Arbitration Act in England got amended. Around the world, there was parallel development. Whatever England tried to do, most of the countries, including USA, tried to borrow it. And interestingly, George Washington was an arbitrator. When coming to India, East India's company's influence was tremendous, which made the first ever legislation to be enacted. Let's go back and see when was the first legislation. The first codified law in England was in 1854. Whereas the first law with respect to arbitration in India was the Bengal Regulation Act 1772, which introduced arbitration, which is much, much prior to the English arbitration law. Then there was what called Bengal Regulation Act 1781, which made partial regulation for arbitration as to how the arbitration proceedings to be conducted. And it said that courts should persuade the parties towards arbitration and award to be set aside if there is misconduct or corruption. So we should definitely say that India is one of the pioneers in the law of arbitration or codified law of arbitration prior to that of England. Then Civil Procedure Code 1859, section 312 and 317 was introduced, which related for arbitration and governing the arbitration, which talked about intervention of court in a pending suit, and with or without intervention, how the arbitration proceedings should be held. And same time, there was statutory arbitration. For example, the Indian Electricity Act 1910 introduced compulsory arbitration in energy-related disputes. So Arbitration Act 1899 was similar to that of English Act of 1899 in India. Then Code of Civil Procedure 1908 came in with inbuilt arbitration provision for under Section 89. This got repealed when Arbitration Act 1940 came in. And thereafter, following the UNCITRAL model, India came out with the Arbitration Conciliation Act 1996, and the 1940 Act got repealed. In 2000, Section 89 CPC was reintroduced by making the courts to refer the parties at dispute before the court and choose any of the ADR options for them. Then we had the Arbitration Amendment Act 2015 and Arbitration Amendment Act 2019. And there's also something as commercial courts, commercial division, commercial appellate division court. Sorry, I should change. It's now called as the Commercial Court Act 2015. Now, Arbitration Amendment Act 2015 we'll be discussing in detail, as well as Arbitration Amendment 2019 also I'll be discussing. Now, commercial courts, commercial division, and commercial appellate division of the High Courts, now we call as Commercial Courts Act, has now exclusive jurisdiction when the matter pertains to arbitration, whether intervention by way of interim order or reference of cases for arbitration or challenging the arbitral award. It has to be done only before the commercial court and not before the normal civil court. So wherever there are cases pending in the normal civil court is getting transferred to the commercial court. That is the reason I thought I should refer this provision. Now, when we talk of New York Convention, everyone, it's a very nice term to wear. It's very fanciful among youngsters to always talk about New York Convention. Okay, what does New York Convention say? It was adopted in 1958 by the United Nations. It came into effect on 7th of June, 1959. So there were various countries who are signatories to this convention, where other name always uses are called as a treaty, which enabled enforcement of a foreign award in a country. For example, there's a dispute between a party in India and party in Japan. And both the country, India and Japan, are signatories to the New York Convention. In the event of a dispute, the matter is referred for an arbitration as provided in the contract. And the arbitrator, assuming the seat of arbitration is Singapore or London, wherever it is, the arbitrator passes an award. Say it has to be enforced against the Indian party by the Japanese party, or will they do it? It's a question. And people realize, the countries realize that there are no consistent rule among various nations. So in order to bring this consistency, this New York Convention came into place, and there were, with 153 countries signatories to it, they agreed that there are certain specific policies that needs to be adopted by various countries, which are uniform, more or less uniform in nature, to recognize and enforce foreign awards in the contracting states. So I talked about the UNCITRAL model law. Basically, it was created in 1996, 1985, then became modified. Last modification was in 2006, which also provides for interim measures, which has now come into play in 2015 amendment. Now, Indian Arbitration Conciliation Act 1996 is based on the UNCITRAL conciliation model rules 1980. This law is different from the 1940 law because it specifically distinguished between domestic and international arbitration. It also recognized conciliation. Though the word conciliation is used, the model law for settlement of dispute through conciliation of the UNCITRAL in 2002 refers conciliation, equates conciliation mediation as one and the same. However, there's no specific distinction in the Arbitration Conciliation Act, even though there's maybe a reference, passing a reference to mediation. So the government of India the Indian Parliament wanted to adopt a new law to replace Arbitration Act of 1940. And thus you had the 1996 Act, which got amended in 2015 and further amendment in 2019. The structure of the Arbitration Conciliation Act is divided in 4 parts. Part 1 relates to domestic arbitration. Part 2 relates to enforcement of foreign awards. Part 3 relates to conciliation. Part 4 relates to supplementary provisions. And there are first schedule refers to Convention on Recognition of Foreign Arbitral Awards. Second schedule refers to Protocol of Arbitration Clauses. Third schedule is Convention of Execution of Foreign Arbitral Awards. And there is also fourth schedule which has come in now, which I should have brought in. It talks about the qualification criteria of arbitrators, and also talks about the fee that needs to be paid to the arbitrators. In part 1, there are broadly 10 chapters on arbitration. The general provisions includes various definitions. Then it talks about arbitration agreement. It discusses what should be the composition of an arbitration tribunal. Then jurisdiction of each of the tribunals as to who has to decide on the jurisdiction. Conduct of the proceedings as to how the arbitration proceedings should be conducted. Whether Civil Procedure Code is applicable, whether Evidence Act is applicable. It talks about, for information, both are totally ousted. It should be conducted on the principles of natural justice. Then making of an award and termination of the arbitral proceedings, and what are the remedies available for a party who's aggrieved by an award. So what sort of recourse he or she can take, and those who have the benefit of having an award in their favor, how can they enforce it, and what is how an appeal can be preferred, and miscellaneous, which I do not want to dwell much because you may be studying, and I don't want to really go in detail about it. The 2 chapters of enforcement of foreign awards is the New York Convention awards and Geneva Convention. Before the New York Convention, there was a Geneva Convention, and which talked about, there's not many countries who are participating in this. New York Convention replaces the Geneva Convention, and which has a broader participation as such. Part 3 talks about conciliation, its application and scope. How does a conciliation commence? Who are the conciliators, number of conciliators, settlement, enforcement of settlement, etc. Now, in the early part of my talk, I referred to conciliation and mediation. What is the difference? The difference is fairly vast. A conciliator is a person at the third party who was engaged by disputing parties to help them to resolve the dispute. Normally, a conciliator is a person who is independent and neutral. But very often we see that a person may not be that independent. He may be a lawyer known to both the parties, or a common person, common friend, can be anyone who's respected by both the parties as such. Now, how does it differ from a mediation? In mediation, a mediator has to be independent, he has to be neutral, and most important, he has to be trained. The mediator, he or she, needs to be trained in various areas and certified and accredited to practice mediation. Mediation is a profession by itself. it is not confined to the legal profession. There are various people, non-lawyers, who are also mediators around the world and including in India. So they undergo specific training, specific hours of training. They undergo evaluation. They have to undergo practical courses, and they are evaluated, and ultimately the certifying authority accredits them as a mediator. Now, this is as far as the person is concerned. The process, both mediation and conciliation, is supposed to be confidential. The process of mediation and conciliation both are voluntary. But the difference between conciliation and mediation is a conciliator can evaluate who's right, who's wrong, can come out with options as to how they can resolve the dispute. Whereas a mediator acts only as a facilitator. He cannot evaluate, he cannot tell who's right, who's wrong, who's got a better case, who's not got a better case, how they should settle. He cannot even suggest options as to ways and means to settle. So it's much challenging and tough task than being a conciliator. But the process is that, surprisingly, world over, abroad, 95% of the cases that are disputes in the US are referred for mediation. The settlement rate is 95%, after the 95%. So only a small trickle of less than 5% goes to the courts. Okay, that is the reason number of cases in the US courts are very less on the civil side. So the conciliation talks about applications, commencement, number of kinds, and how the settlement to be drafted, and enforcement of a settlement. Now, what do we do in India as such? There is no specific law for mediation as such in India. So mediators, what we do, the ethics of mediation is followed. Every high court has created rules for mediation. The same rules have been adopted more or less by the private mediation centers. But when they try to draft the settlement between the parties, it is drafted as if it is a settlement arrived out of mediation under Section 73 of the Arbitration Conciliation Act, which is enforceable under Section 34 and 35 of the Arbitration Conciliation Act, which is deemed to be, it amounts to a consent award. A consent award means deemed to be a decree which is enforceable and cannot be challenged in appeal, and straight away it can be enforced. So the advantages of mediation outweighs arbitration tremendously, because it takes less than 2 or 3 sittings to resolve a dispute through mediation. And that is the reason today there's a tremendous amount of demand for mediation, and people are going for mediation. I'm sure you have been following up that Supreme Court, even our Chief Justice, Lord Chief Justice Bopde, wanted mediation to be practiced effectively, and there's going to be there may be a mediation law bill coming in very soon also. So this is the basic distinction between conciliation and mediation. But the rule is that all mediation are conciliations, but all conciliations are not mediation. Why am I talking about mediation? When I'm talking about arbitration, there's a relevance. We'll come to that too. Now, what is the scope of arbitration? The scope of arbitration, there should be parties to a contract. So what is it? Arbitration cannot just be used unless and until there should be parties to a contract, and the contract should provide for an arbitration clause. That means if in the event of a dispute, the parties will not go to the court, but will go for an arbitration, and it should be in writing. And they also agree that the award that is passed will be final and binding. So needless to say, that document has to be written document. The Supreme Court has gone ahead and widened the scope of written document. It can be a contract, even by way of exchange of emails or a telex or fax, whatever it is. And it need not even be signed by the parties, as long as a communication, proof of communication has been exchanged between two parties agreeing for an arbitration. So this is called as the implied admissions. So the Supreme Court, as well as most of the courts around the world, has accepted these sort of communication exchanges that implies that the parties intend to have an arbitration. so that with such an implied admission, a party is prevented from going to the court and trying to oust the jurisdiction of the arbitration tribunal. Then, what is the scope of arbitration? The dispute should stem out of the contract. Assuming A and B are doing a particular business called C. A may have, and there's an arbitration agreement between A and B with respect to business C. But there may be also a different business altogether. So A and B may be doing a construction business, but A and B may be doing a shipping business. There may not be a contract at all. In the construction business, there may be an arbitration clause. So it is only the dispute that arises out of the construction business can be referred for arbitration. It cannot, any dispute that arises other than the construction business, say if it's in the export business or shipping business, cannot be referred for arbitration. So what qualifies, what triggers up the jurisdiction of the arbitration tribunal? There should be a breach of contract. And the breach of contract should result in a dispute between the contracting parties. And the dispute is not being resolved, then the parties will go for arbitration. Now, how do they, how does the arbitration tribunal constitute? The arbitration clause normally should provide for either they appoint a sole arbitrator, all the other parties will appoint a sole arbitrator, or each of the parties appoint one arbitrator. Now, the issue is odd and even. Assuming that a party A and party B, A appoints X and B appoints Y, what happens if there is a tie between X and Y and they are not able to resolve the disputes? So, the ancestral recommendation, which is adopted in India, follows the principle that X and Y shall appoint Z, a third person, as a principal arbitrator. So, in order to break a tie as such. But generally, the award is passed normally by the three arbitrators. Each one, either they may agree and by way of consensus, or they may differ. It is up to the arbitrators, the tribunal, as we call collectively, that's called as the tribunal, to decide how they come out. Now, the sole arbitrator can be mutually appointed by the parties, or in the contract itself, they may, at the time drawing the contract, they may say, okay, we'd like to appoint so-and-so as an arbitrator. Maybe I want to have if there are two partners, they would like to have an arbitrator, their chartered accountant as an arbitrator, or as a firm's lawyer as an arbitrator, because people believed in confidentiality. They did not want the dispute to spill to the courts as such, and they wanted everything to be done very fast. So, predetermine name the arbitrator, or they may ask an institutional arbitrator center to appoint an arbitrator. If the parties have incorporated an arbitration clause downloaded from the BIMAC, or saying that in the event of a dispute, the parties will approach BIMAC for appointment of arbitrator under the BIMAC rules. Then it is for the institute to appoint the arbitrator depending upon ascertaining whether there are various factors like conflict of interest, etc. Now, what happens if in case they don't agree for this? I'll answer this after. Similarly, the three-member arbitration also can be decided by the arbitration tribunal. Now, if the parties do not agree for the arbitration, they may approach the court to appoint the arbitrator, which we'll be discussing later. The court, after issuing notice to both the parties, may decide whether there's an arbitration clause, and if the clause exists, then they may appoint an arbitrator. The court may appoint an arbitrator of its seeking the consent of all the parties, or may choose someone from its own panel or from an institute as such. Now, post amendment to 2015, an arbitration tribunal can also pass interim relief. Prior to 2015, one can seek intervention of the court. Before you appoint an arbitrator, someone wants an interim relief. You might file an application to the civil court and say, I want an order of injunction. I've invoked the arbitration. I've sent a notice for arbitration. But in the meanwhile, we feel that there may be a damage to the property. So please appoint an arbitrator. Please pass an interim order. Okay. Now, this interim order also can be granted nowadays by the arbitration tribunal itself. So as I said, section 11 comes into play. When a party fails to appoint an arbitrator, they can go to the High Court for a domestic arbitration and to the Supreme Court for appointment of arbitration in an international disputes. And the time limit fixed by is about within 60 days. The High Court or the Supreme Court should dispose of the application for appointment of arbitrators. And law is very clear that if there is an arbitration clause, the court should not try to conduct a roving inquiry and whether the arbitration clause is valid or not. It's simple that if there is a arbitration clause, the parties have to go for arbitration. You'll be surprised by these terms, these are all hybrid ADRs, which are related to arbitration. ARB-MED, that is a combination of arbitration and mediation. That in the event, when there is an arbitration clause and a matter is provided for arbitration, the arbitration tribunal can refer some of the disputes for mediation. Contracts also provide for ARB-MED clause these days. Next is called MED-ARB. That is mediation and arbitration. Parties can refer a matter for mediation. If the mediation is not successful or partly successful, the rest of the dispute, the entire disputes can be referred back, sent for arbitration. There's another combination called MED-ARB-MED. That is, from mediation, it goes to arbitration and can come back for mediation. And that is called ARB-MED-ARB, arbitration, mediation, and go back to arbitration. These are very, very common. And of course, you will not find this in your law books. There's another combination, as I said, neutral evaluation and mediation. A party can go to a neutral evaluator and find out whether he has a good case to fight litigation. If he says no, then the neutral evaluator may send the matter advise the party to go for mediation. Then in a mediation process, the parties may be asked by the mediator to go to a different person called neutral evaluator because the mediator cannot do neutral evaluation. So he goes to other party, sends them to a different party for neutral evaluation. The neutral evaluation also exists when neutral evaluator can also refer matter for arbitration. And in arbitration, matter can be referred by the arbitrators for neutral evaluation. An tribunal can refer the matters for collaborative settlement, which is called cause. And collaborative settlers also can refer the matter for arbitration. So this is the various permutation and combination available and options available. And this is where the term alternative as well as appropriative dispute resolution process comes into play. You understand? So it's very important you as young law students and future lawyers should understand that the scope of ADR is not just arbitration, that there's a combination of these various hybrid systems. And the scope of arbitration is to be exploited, or ADR should be exploited by young lawyers who still do not know what to do when it comes to arbitration as such. You see a big wall in this. And I call this an Indian arbitration wall. and it seems to be very damaging. There's a huge hole in it, right? This is the perception of various people, both in India and abroad, about the Indian arbitration system. There is a resistance to arbitration and awards in India. Why so? Because arbitration clauses in contracts are being used without understanding pros and cons of arbitration. Unfortunately, for quite some time, people felt that arbitration is something much, much easier than going to litigation. Yes, it is true. But there are the flip side of arbitration, which people tend to ignore. And if you expect the arbitration tribunal to function like a court, civil court, you're thoroughly mistaken. So they get disappointed. You can't keep file IAS after IAS and IAS after IAS. It'll be rejected. Once you reject, if the applications gets rejected, you can't try to treat an arbitration tribunal like a court. If you try to explore all the provisions of civil procedure code, you're going to cut a sorry figure. You will be disappointed. The law act itself says provisions of civil procedure code cannot be applied. Evidence Act cannot be applied. It is going to be decided only on the principles of natural justice. If that being the case, that with such a mindset, and if they feel frustrated that the arbitration is not something desirable, did not live up to the expectation, and they feel disappointed and try to challenge the award because it did not come in their favor. So the mindset of people have to change. They should understand how an arbitration tribunal should function. Every award gets challenged these days. Section 34 is invoked, a civil suit is filed. Till recently, the moment you file a civil suit, the award gets stayed. And the suit will take years and years for the matter to be taken up. And the entire purpose of speedy disposal in an arbitration is defeated. Then other aspect is the cost involved. I always tell my friends, young students like you, the difference between litigation and arbitration is that litigation is going and having a food in the restaurant. Arbitration is having the food, room service in your room in a hotel. There is always an extra cost for the service. So arbitration is so expensive compared to a litigation as such, because in India, the litigation is horribly subsidized by the government. You can file a suit for injunction by paying 100 rupees. A writ petition is filed, the cost of filing a writ petition is 100 rupees for the past 30, 40 years. Rupee value has diminished considerably, and how do you expect the judiciary to take the burden? But still, the cost as far as a court fee is concerned is very low. But that is not the case in arbitration. And people want the best of the judges to be the arbitrators. They are willing to, and just because some of the companies are well off, and maybe the top companies in the country or in the world, they pay lakhs and lakhs of rupees as arbitration fees. The system is this practice has somehow percolated that even in a small arbitration, the fees is expensive. There are cases where for a 10 lakh dispute, 20 lakhs is spent on arbitration fees. So it's shocking for many people. And many a time, because of various other factors, the manner in which an arbitrator was being appointed, resulted in allegations of misconduct against arbitrators, and the award has been challenged. That apart, for the drop of the hat, people were approaching the courts, and the courts were interfering liberally in arbitral proceedings. And awards were being challenged on very, very flimsy grounds. As I earlier said, that the moment you award is challenged in section 34, there was automatic stay. Now, the world over did not consider India as an arbitration-friendly country. Even now, the same perception prevails. Not that easy to dispel the doubts that they have about the Indian arbitration system. The reason is they find it extremely difficult to appoint arbitrators in international disputes. It takes months for them to move the Supreme Court and get people appointed. There's always a resistance. Then it's not easy to enforce a foreign award. There's a delay in enforcement of foreign awards by the execution courts. And there is always a steep hierarchy of appeals. And above all, there's been inconsistent judgments. What law is law today is considered to be a flaw tomorrow by the court. What is law tomorrow may be considered to be a flaw by a court maybe the other day, in the near future. So this sort of inconsistency troubled people with respect to Indian arbitration system. So the demand was, okay, we'll not have arbitration, we'll have an arbitration clause, but it will not be under Indian law. It will be under foreign law. And let us have the seat of arbitration outside the country. You won't believe, it's strange. Two Indian companies. One is Reliance, other one is ONGC. They had an arbitration clause with the English law, and the seat of arbitration is London. Is it not shameful? We do not even respect our own system. But this is the impression that we have created. We should have pride in our own law, and we should try to make the change, and we the lawyers, and you, the future lawyers, should make effort to change the system. The court, Supreme Court, as well as the government is trying their best to bring in a lot of change in the recent past, which we'll be discussing. When they talked about the efforts made by the government and the courts, we saw a major amendment coming into play by way of amendment to the Arbitration Conciliation Act in 2015. I have maybe another 20 minutes or so. So the first amendment was with respect to interim relief. In the famous case, Balco case, interim orders made by arbitral tribunals could not be enforced in India. It said, listen, interim orders, foreign interim orders, how can we interfere? The court should not get involved in it. So there was an amendment to Section 2, which enabled enforcements of interim reliefs. So it enabled application of international commercial arbitration. Interim awards passed in these international commercial arbitration outside India that can be enforced in India. But if two Indian parties who choose to arbitrate outside India, as I said in the case of Reliance versus ONGC, then they can't derive this benefit. And then it also fixed a time limit of 90 days. Okay. So within 90 days, if an interim order is passed by a court before commencement of the arbitration proceedings, the interim order will lapse if the arbitration proceeding is not commenced within the period of 90 days. Now, Section 17 got amended, which enabled the arbitration tribunals to grant interim relief. Prior to that, the arbitrators could not grant interim relief. They could not order attachment before judgment. They could not pass an order of paying interim interest. They could not pass order of injunction, which was totally exclusive jurisdiction of civil court under Section 9. And strangely, the law says that amendment enables the tribunal to pass interim order even after passing the final order. This is a bit strange because the tribunal becomes functus officio. But still, on what basis it can pass interim order, it's puzzling, but that's a law today. Section 8 got amended too. Earlier, the power of the court was to conduct a roving inquiry whether there's an arbitration clause, under what circumstances the arbitration agreement was signed, whether it's lawful, all that. Section 8, after amendment, says nothing doing. If there's an arbitration clause, it's not the business of the court to look into it. It is the jurisdiction. Even if there's a question of limitation, jurisdiction, all this should be looked into only by the arbitration tribunal. And the court was told not to get involved. Section 34. The scope of Section 34 is that the term public policy created a huge issue, especially when it comes to foreign awards. A talk on public policy will require another 3 hours. I'm not going to talk about it. I want you people to read, do research, very interesting judgments of various Supreme Courts conflicting with each other. I request you all to look into it. Now, as I said, there was inconsistent judgments of the Supreme Court with respect to public policy. The Parliament decided to come out with an amendment and narrowed the scope of public policy. The court can interfere and set aside award only if the award has been induced or affected by fraud or corruption, whether if the award is in contravention with the fundamental policy of India, and it basically affects the morality, basic notions of morality or justice. Well, this Act of 15 narrows down the scope, but still there is a lot of room for litigation on the question of contravention of fundamental policy, what is morality, what is justice. Well, time only should tell. And as I said earlier, when Section 34, application was made to set aside an award under Section 34. Prior to Amendment of 2015, there was an automatic stay. Now that stay Amendment of 15 has abolished the stay, and you have to make an application to get an interim award and get an order of stay of the award. If you're not able to convince prima facie that the award is bad in law, you will not get an order of stay. The 2015 amendment said that prescribed a 12-month period within which an award has to be passed. It can be extended by another 6 months. Thereafter, it created a situation where the entire arbitrator is totally unseated. This created a problem that people have to go to another arbitration tribunal and start everything from scratch. It defeated the very purpose of fixing the time limit. And Section 29B was introduced, which provided a fast-track mechanism by which within 6 months, the entire arbitration proceeding should be concluded. This is from the date of receipt of appointment of arbitrators, when I say that. And the most interesting part is that it is decided only on the pleadings, that is claim, statement of objections, and counterclaim, if any. There is no evidence, no oral evidence, and no oral arguments. And for the first time, Section 31A was introduced, which empowers an arbitration tribunal to impose costs on the parties for having wasted the time of the tribunal or wasted the time of the opposite party, of the winning party. Schedule 5 and Schedule 6 has been introduced, provides disclosure of interests of the arbitrators and eligibility criteria for appointment of arbitrators. I should tell friends that prior to this, various organizations had a panel of arbitrators. They are being paid retainer, virtually their employees. They may be judges, they may be Supreme Court judges, they may be sitting judges, retired sitting High Court judges or retired judges of Supreme Court or any other judges or even any third party, they'll be on a monthly retainer. In addition to it, they are appointed as an arbitrator and then they will be getting the fees. They are not independent. So the law now provides that they have to disclose what is the interest and how they connected with either of the parties. It also prescribes various eligibility criteria for appointment of arbitrators, which gets modified in Act of Amendment after 2019, which we'll discuss later. Now, on 30th July 2017, Justice Shri Krishna, a very reputed judge of the Bombay High Court, heads a high-level committee to review institutionalizing of arbitration mechanism in India. So he submits a report to make India a hub of institutional arbitration for both domestic and international. And this leads to the amendment to the Arbitration Conciliation Act of 2019. Now let us have a glimpse of these amendments. Section 1CA defines arbitration institution, and this has to be designated by the Supreme Court or High Court. So once this comes into play, like institutions like BIMAC will be designated as an arbitration institution by the High Court or the Supreme Court, as the case may be. Then Section 11 gets amended, where rules have been there, law has been laid as to how an arbitrator to be appointed for a domestic dispute as well as an international disputes. How the institutional arbitrations centers should provide for the appointment of arbitrators. Where there is no institutional arbitration center, what should the High Court do? How they should draw the panel of arbitrators and how they should determine. And also talks about the fees that needs to be paid to the arbitrators and the fee structure to be determined and approved by the arbitral tribunal. And the arbitral fee has been described in the 4th schedule. Another important step towards institutional arbitration center to create Arbitration Council of India. There should be a chairperson who is a judge of the Supreme Court or a chief justice of a High Court, and it will comprise of maybe several eminent members from the bar, arbitration practitioners, academicians, secretaries, etc., and professionals drawn from various other professions. And the idea is to promote ADR in general, arbitration in particular. They are supposed to create a framework for institutional ADR centers and also recognize professional institutes for providing accreditation for arbitrators. Section 23 contemplates and fixes timeline for fixation of arbitrators. There are cases which are pending for several years before the courts, even for appointment of arbitrators. Now, they say that within 6 months, the court should appoint, on filing application, the court should appoint an arbitrator. And an award should be passed within 6 months from the date of appointment of arbitrator. An arbitral award for international arbitration should be passed within 12 months, and there's a possible of extension by way of application. Let me skip 34 and 35. It's not very significant at this level for you. Then the amendment also provides criteria for arbitrators. It makes mandatory 10 years of professional service. You may be a lawyer, chartered accountant, company secretary, engineers or doctors, or you may even be a bank employee or serving in any organization or working in the government. You should have at minimum 10 years of service or practice. What is more important is that it makes mandatory that an arbitrator needs to be conversant with Constitution of India, should know what principles of natural justice is, what is equity, what is common law, customary law. You should know commercial law, labor law, law of torts, and should have knowledge as to how an arbitral award can be enforced, and the intricacies of domestic and international legal system on arbitration, and what are the best practices abroad. And above all, the art of drafting a reasoned award. So gone are the days that one can appoint Tom, Dick, and Harry as an arbitrator. So one has to, arbitrators have now to qualify and get a certificate from an institution. Post 1995, it has been made very, very clear that the entire arbitration process is confidential. That means if the court wants to call for the proceedings, it cannot. If there is an award, only the award can be challenged. It becomes part of the, can come out in public. Apart from the award, no other proceedings, maybe the case-to-case, day-to-day, or the hearing details, all this cannot be shared in the public domain or even called for by the court. Now, this becomes a very controversial issue. Section 26 of 2015 Act read this: nothing contained in this Act shall apply to arbitral proceedings commenced in accordance with provisions of Section 21 of the Principal Act before the commencement of this Act, unless the parties otherwise agree, but this Act shall apply in relation to arbitral proceeding commenced on or after the date of commencement of this Act. So the question is whether the amendment by way of Act of 2015 should be retrospective or prospective. So this provided that it should be prospective. Now, in the matter of BCCI versus Kochi Cricket Private Limited, the Supreme Court said, so what the amendment to a 2019 amendment came out with Section 87 and said the 2015 amendment will be prospective, not be retrospective. And accordingly, Section 26 got deleted. This amendment was done because in BCCI versus Kochi Cricket Private Limited, the Supreme Court held that the amendment, 2015 amendment, should be retrospective. The issue was with respect to automatic stay under Section 34 of award passed by the tribunal. As I said, when the moment an application that Section 34 was filed, there was an automatic stay of the award. 2015 said, no, unless and until an application is filed, you cannot, I think the stay does not come into play. So from 2015 Act says that you have to file this application. Now, whether this comes retrospective for awards passed prior to the amendment or not is the question. The Supreme Court in BCCI versus Kochi Cricket said that it has to be retrospective. In order to overcome that, this amendment under Section 87 was brought in and said it has to be only prospective. Now, this once again was challenged. In the case of Hindustan Construction Company versus Union of India, the Supreme Court said, sorry, this is totally unconstitutional. You can't play around with this. It affects the entire spirit of our amendment to the Arbitration Conciliation Act. So it has to be retrospective. Okay. So these are some of the case laws which I want you people to read and learn and understand and keep reading. Okay. This ADR arbitration is a never-ending process. It's so fluid and flows like a continuous water that you people need to keep yourself abreast. If you miss out on any decisions, you may be lost. Okay. So with this, my talk on this is over. But now we are talking about institutional ADR center by which this Amendment Act of 2019 brings in. It's So let me briefly talk about what Bangalore International Mediation Arbitration Conciliation Center is. So it is India's one and only international not-for-profit ADR resolution center. It was launched on 23rd September 2013 and is said it's a not-for-profit body registered under the Income Tax Act, promoted by judges, lawyers, chartered accountants, etc. And it is India's answer to Singapore International Arbitration Center, ICC, AAA, Hong Kong Arbitration Center, CTAC, etc. in its own way. But let me tell you, in the past 7 years, we have achieved tremendous progress. Now it's rated as one of the top 25 in the world. So BIMAC provides international domestic arbitration, international domestic mediation, international that is neutral evaluation, collaborative settlement, mentoring, conflict management, and academy. Academy involves teaching. So it is headed by former judge of the Supreme Court, is presently the Lokayukta of Kerala, Justice Cyriac Joseph, who was former member of the National Human Rights Commission, and he was also the Chief Justice of High Court of Karnataka. We have another Vice Chairman, who is Justice Deepak Verma, who is an international arbitrator, former judge of the Supreme Court and Chief Justice of Rajasthan High Court. Another Vice Chairman is Justice S.R. Banurmat, who is presently the Chairman of the Karnataka State Law Commission, and he was the former Chairman of the Maharashtra State Human Rights Commission. He was the Chief Justice of High Court of Kerala and Judge of the High Court of Karnataka. We have Dr. Lalit Basan, who many of you may know. He is the President of Society of Indian Law Firms. He's a senior advocate. He's also President of Bar Association of India. He's the Chairman of the Chartered Institute of Arbitrators of India. Then we have a very eminent person called Ghanshyam Das. He is currently the advisor to the consulting company called KPMG. He was the former MD of NASDAQ Asia. It's a stock exchange in New York. He was MD of a very famous bank, Wells Fargo, and was head of Asia Pacific HSBC Bank. Then we have a former IAS officer who was responsible for the IT revolution in Bangalore. So he's Mr. Vivek Kulkarni, was the Secretary of IT and BT in Government of Karnataka, and is the chairman of a company called Brickwork Rating. He's a visiting professor at Indian Institute of Science, a former member of SEBI. We have another board of governors, who's Mr. Dr. Professor Sivakumar, who is a professor of Indian Law Institute, New Delhi. It's a law college run by the Supreme Court. He was a former acting member, director of this institute. He's a convener of the Commonwealth Law Commission and former member of Law Commission of India. We have another educationist, Dr. Chandra Roychand, who is chairman of Jain Group of Institutions. We have an eminent chartered accountant, Mr. Nagin Kincha. And we have an overseas member who is the founder of CEO and we CEO of a company called Vectraspan. He was involved as a CEO of NIT Ventures in USA. We have a very famous lawyer, senior lawyer, Mr. K.G. Raghavan on our board, who is an international arbitrator too. And this is yours truly. I don't want to dwell much on this. And we have a registrar, honorary registrar, Mrs. Revatiya, who's a patent agent and mediator. Now, BIMAC has been having, as I said, we have international rules for arbitration mediation. Now, UNCITRAL has acknowledged that the rules of BIMAC is being administered, the rules are in consonance with UNCITRAL rules, administering arbitral proceedings under the UNCITRAL arbitration rules and providing administrative services, and also BIMAC acting upon authority under the UNCITRAL arbitration rules. It's a great privilege to BIMAC. And the Government of India, Ministry of Justice, recognizes BIMAC as an ADR center which provides various services, including online ADR. BIMAC is affiliated with various centers like the Federation of Mediation Centers of France, International Arbitration Center Cairo, Kunming International Arbitration Center, Chinese ASEAN Macau Arbitration Center, Hong Kong International Arbitration Center, in Media Zone Italy, Brazil Mediation Center, Sri Lanka Canadian Center, and several other institutions are affiliated with us, like Society of Indian Law Firms, Bar Association of India, Chartered Institute of Arbitrators. We support and mutually support each other with various institutes around the world, including India, Chicago Kent College of Law, Illinois Institute of Technology, National Law School of India, University Bangalore, National Law School Jodhpur, SDM College, so several other universities and professional organizations. So our academy provides accredited certified courses in mediation, commercial mediation, advanced commercial mediation, various levels of arbitration training, neutral evaluator training, collaborative settlement, and mentoring in conflict management, advocacy skills. So thank you very much for your participation. And I also need to inform you and students that BIOMAC is currently in the middle of an ADR promotional campaign through series of informative, educative blog articles in a series called A to Z of ADR. So please follow BIOMAC on Facebook, LinkedIn, and Twitter and Instagram to learn more about it. We also welcome blogs and articles from each one of you. Good articles will be selected by our review team and be put up in a blogs. We conduct also free webinars every week, and they are all uploaded on YouTube. So with this, I end this talk, which is fairly long. Thank you for your patience. I'm sure, let me also apologize if it had been a bit overbearing, but I thought it's nice to share my thoughts with you all. I welcome any questions. If it's possible, we'll definitely take it forward. Over to you, Professor Vidya.
Thank you, sir. Chandra, she's moderating the questions in this session, sir.
Pardon me?
Chandra,
Yes, please type down your questions, Srinivas. Please put it in the chat box. Thank you so much, sir. That was very insightful, and I hope and I feel that the students, whoever, they have all done this 2015 amendment and 19 amendments, and I think it was a quick revision and brush up of all the things that done in the class, and we have had to learn a lot more from you. Thank you so much, sir, for your time. We are open for questions. If anyone has any question, please.
Can I ask it?
yes, Srinivas.
Sir, good afternoon, sir.
Good afternoon.
Sir, my name is Srinivas. I would like to ask you very fast and small questions, sir.
Okay.
Sir, when you're talking about that graph, sir, from that pie chart, from your pie chart,
Yeah.
where you said politicians, policies, and bureaucrats as underworld, sir, where they're settling the matter from underworld.
No.
So why did you?
One second. Let me correct. You have not read the graph properly. The underworld segment is separate 9%. Okay?
Sir,
Underworld segment 9%. They are not included with politicians, police, and other interveners. So don't get it mixed up.
Thank you, sir. I think Srinivas, he has answered your question well.
Any other questions?
Yes, sir. There's one question from a student from BPA LLB 7th semester, Anshika Bhushan. She asks that in one of the slides it was mentioned that the reason for resistance to arbitration in India is the regular interference by the court. But isn't the court's jurisdiction ousted by way of the arbitration clause?
So the court jurisdiction is definitely ousted. Hello?
Yes, sir, we can hear you.
It is on paper hosted, but there are certain things when complaints goes, see, how does the judicial system function? The judicial system functions in such a manner that it welcomes people to come out with the problems. If you or me go to the court and say, listen, the principles of natural justice not followed by this particular court, by this arbitration tribunal, they can't say straight away throw it out. They say, okay, let us examine it. Okay, but the process of examining gets delayed. In the process, when that happens, then it interferes with the process in the arbitration proceeding is as such. Now, the main issue is we have an arbitration clause. According to me, I believe there's an arbitration clause. Now, we lawyers are very smart. We do not want an arbitration to happen. So what do? I say, listen, the dispute that has been raised by the opposite party who wants an arbitration is beyond the scope of the arbitration clause, beyond the scope of my contract. So there cannot be an arbitration. So what do? I oppose that straight away. I challenge the jurisdiction of arbitration. It amounts to interference. An award is passed. Now, I make various allegations, what good, right or wrong, saying that there is a misconduct. These facts have not been appreciated. These facts have been omitted. The evidence has not been looked into properly, or there is a prejudice, there is a bias. There is innumerable ways to challenge this. Fortunately, what has happened, to an extent, the legislation, the parliament has tried to put an end to this, reduce it. I'm not saying put an end, to reduce it. Earlier, as I said, Section 34, the moment I file an application challenging award under Section 34, there was an automatic stay. That benefit is not there. Now you have to go and argue before the court and say, listen, why I want the stay? These are the valid reasons. There's a patent violation of principles of natural justice. These are the issues that should have been looked into, but is not been looked into. Or there is a fraud committed by the parties. There's a fraud committed by the arbitrators, or there's a misconduct. It has to be established prima facie for the court to grant a stay. So today it's not easy to get a stay. And the statistics shows that it is only in 2 out of 100 cases a stay is granted. Where in 100 cases, prior to 2015, the moment you file a challenge petition in 34, there was automatic stay. In a democratic society and the courts being pillars of democracy, you can't just throw out a person not to even come to the courts. So there should be a balance somewhere, and that's how the Amendment Act of 2015 and 19 tries to bring a balance.
So could you, so there's another question. So could you just throw some light on the pre-Konkan and post-Konkan railways case, and what is the current scenario with regard to the appointment of arbitrators?
I need 1 hour time for that, ma. Okay?
Okay.
As it is, my lung is exhausted.
So are we taking any further questions, or we are calling it off here? Okay, sir. One more question, sir. In the hybrid form of alternate dispute resolution, like you spoke about med-arb-med, so the student asks that whether while shifting from mediation to arbitration and from arbitration to again mediation, the reference is made by the arbitrator who's dealing with the matter, with the dispute, or is it by the parties themselves?
See, when it's an med-arb means the arbitrators may ask the parties whether they'd like to get certain of the issues resolved through mediation, or can be a request by the parties themselves. So it can be mutual as such. In mediation also the same thing. It is in mediation, the mediator will refer the matter to arbitration. Mediation, it's the parties who would seek that, okay, please resolve these things. We'll get these things resolved through arbitration. So it'll be a combination. Mediation is a non-adversarial approach, and arbitration is an adversarial approach. So that's how the hybrid comes into play. And let me also clarify, if I'm an arbitrator, I cannot be the mediator.
Right.
And if I'm the mediator, I cannot be the arbitrator. So it will be 2 distinct persons.
Ma'am, I think there's no further questions. Over to Roshni, ma'am.
I see a lot of tired faces.
Over to Roshni, ma'am, for the formal vote of thanks.
They're engrossed with your talk, sir. In your talk.
Gratitude is the fairest blossom which springs from the soul. I, Roshni Tamaya, on behalf of CMR University School of PG Studies, consider it a great privilege to propose a vote of thanks to all people involved in making this webinar. Firstly, I would like to thank our keynote speaker, Mr. B.C. Thiruvengadam, sir, for delivering such an interesting lecture on on helping us understand and us as well as the students understand various aspects of our education, from the history to the latest amendments. Thank you for that, sir. I would also like to thank our respected Dean, Professor Dr. Subramanya, our VP, Professor V.J. Praneshwaram, and also Vidya ma'am for always being a constant source of support and motivation and ensuring this webinar is conducted with, it was conducted without any hassle. I would also like to thank the faculty involved, Mrs. Ramya ma'am as well as Chandrupa ma'am for their dedication and aid in helping with this webinar. Last but not least, I'd like to thank all of you students for attending and listening with such rapt interest in making this webinar a success. Thank you, everyone.
Thank you very much, Roshni. I thank once again everyone for patiently listening to me and hope I lived up to your expectations.
Thank you, sir. Thank you.
And thank you, Dr. Subramanian, sir, for having sat through this. And thank you, Vidya, and all the staff members. And I look forward in your institution cooperating and with BIMAC. And BIMAC is always there to support any service of any legal service activities of all the any institutions in the country.
Thank you. Thank you.